I'm Alan Kimbrough. I'm the Executive Director of the Maricopa County Bar Association. We want to welcome you to the MCBA's offices if you haven't been here before. We're delighted to have you participate and be a part of this public forum on questions related to the unified or mandatory bar in Arizona. We have, through the years, done a series of public forums, and we expect to do even more next year as we move into the election year. We previously did one, if some of you were here, on the proposed dues increase at the state bar and had people from both sides. This is not a debate as such. It is a forum. It is intended to be informational to those of you who are here, our members primarily, and the public. The participants have agreed in advance on a format that we will follow today. And so let's, without further ado, go ahead and get started. Let me introduce you to our panelists, to our participants today. First, to my left is John Phelps, who is the Chief Executive Officer and Executive Director of the State Bar of Arizona. John has a long and very distinguished career, both in the Judge Advocate General's Corps and also as a nonprofit administrator. He is an Arizona attorney, is a graduate of the University of Arizona College of Law. He has been with the bar since, I believe, 2008 or 2009, something like that, and we welcome him today on behalf of the bar. Next to him is Jeff Trachtenberg, who is the current president of the State Bar of Arizona. He is also admitted to practice in California, New Mexico, and Utah. He received his law degree from UC Berkeley, Boalt Hall, in 1997 and has practiced here since 2002. Jeffrey's practice is in injury and wrongful death litigation. Next to him is Paul Avilar, who is the senior attorney with the Institute for Justice. Paul has been in Arizona since 2010, where he is a native Arizona. He's a graduate of ASU College of Law, and he also has an undergraduate degree from Princeton. He clerked for the Second Circuit Court of Appeals for Justice Hurwitz on our Supreme Court and Judge Daniel Barker of the Court of Appeals. He works in areas of free speech and association, and I think you will find Paul, most importantly to today's discussion, Paul was a member of the recent Arizona State Bar Task Force to study the mission and governance of the State Bar. Next to Paul is Jared Blanchard, who is with the Goldwater Institute, and he is a staff attorney in their institute, the Scharf Norton Center, for Constitutional Litigation. He was in private practice in Florida before that. He's a graduate of Florida State College of Law, go Seminoles, and he has had other very distinguished things in his career. He is involved currently in the federal lawsuit in North Dakota challenging the North Dakota bar's the constitutionality of the mandatory bar in North Dakota, as well as their deficient standards in the Keller arena regarding lobbying efforts of the state bar. So how we're going to proceed today, we will begin with Jeff and John, who will have 10 minutes to lay out the issues that are being discussed here at the legislature and otherwise. We will then go to Paul and Jared, who also have 10 minutes. Thereafter, each side, I hate to use the word side, but there are sides, I suppose. Each side will have 5 minutes to do a rebuttal or any clarifications of the positions of the other people that have been offered. And then the part of the program I think that will take the remainder of our time and will be the most active and energetic will be questions from the audience. We want each of you to be involved in this process and ask any questions that you have. Again, we're here for information. And with that, I welcome our panelists and turn it over to Jeff and John.
Thank you, Alan, for hosting us, and thanks to all of you for coming out to see what we have to say. My involvement in the bar began about 4 years ago. I'm an unusual player. I haven't been one of these folks that's been tied up in the bar for a decade or more. So I don't consider myself to be an insider in the traditional sense. But since coming to the bar, I've learned a tremendous amount. I've learned about things that the bar. I'll just lean into it. Better? I've learned things that the bar does, things that the bar can't do, and things that the bar doesn't do that some people think they do. And the reality is, much of what we do, we don't communicate it very well. And we've been working on changing that. We provide a lot of benefits to attorneys. We provide a lot of benefits to the public. And we haven't communicated it all that well. But the reality being is that the discipline portion of the bar is not really a big part of what the Board of Governors does, but it's a big part of what the bar does, right? And so it's about half of what the bar does, if not more. And it's under the auspices of the Supreme Court. The bar acts as a prosecutor in the sense of vetting cases, but ultimately it goes out to another agency, another auspice of the Supreme Court. It goes to the Judge O'Neill's court, which then decides where it's going to go from there. And so I guess my point is a lot of people misunderstand what the bar does and what we're out there doing for folks. And I think part of it is on us. I think we haven't done a good job of communicating it. But part of it is just generally misunderstanding the role of the Arizona State Bar. And I will also tell you, as Alan was saying, you know, I'm a member of 3 other bars. And I'm not just some, you know, half member. I'm a full-fledged active member. I litigate cases in other jurisdictions. I'm active in their bar associations. I'm part of the various associations in that state. And I will tell you that there is nothing that holds a candle to our bar and the professionalism, collegiality, availability of services to members at a very reasonable price. So not everyone's going to agree with me, and I accept that, but the simple fact is we run a very good ship here, and I'm proud to be a part of it. And again, I'm not what you consider to be the ultimate insider who's built a career on being part of this bar. And truth is as Mark will tell you, you know, once you're done as a president, they put you, you know, you get another year, but then they put you out to pasture. So you know, I'm giving it to you straight.
Thanks, Jeff, and thanks everybody for coming. I thought I'd just take a couple of minutes and talk a little bit about kind of the genesis of the integrated bar, where it came from, how we got here in Arizona, because I think you know, understanding our past is important to understanding where we're at now and where our future may lie. The integrated bar is a model that has been adopted in 32 states and the District of Columbia. So it's in a majority of the jurisdictions where you find this model. And the model really came out of a movement in the early 1900s by the American Judicature Society that recognized that the law and the practice of law in particular by attorneys was unique, and that it demanded more than just simply representation of clients, but that as a member of this profession, this noble calling, that every lawyer had an obligation to the public. And that obligation goes to the improvement of the quality of legal services. It goes to the investment in the administration of justice. And the thought was then, and is now, that because of this special obligation, every lawyer, every attorney must participate. Now, some attorneys choose not to participate in the actual activities and programs of the bar, but the bar is engaged, as Jeff said, in a lot of different areas that are focused on improving the practice of law, which inures to everybody's benefit. I mean, we lawyers benefit from other lawyers being more competent and capable and ethical, but most importantly, the improvement and of the professional development of attorneys inures to the public's benefit. We raise the standards, we enforce the standards, we change the standards as time changes, but that idea that every lawyer has an obligation and nobody gets a pass from that. Nobody gets to say, you know what, I'm going to opt out of that. I'm not going to be a part of that special profession. I'm just going to be I'm just going to be a member of an occupation rather than a profession. And that's the fundamental underpinnings, the sort of the fundamental principle that really is the foundation for the integrated bar concept. And if you don't, as a lawyer, buy into that idea that there's this noble profession that requires more than simply going to work every day, which is certainly important, but that there's this larger obligation and everybody's a part of it, then there's nothing I can say or do that will, I'm sure, change your mind. But that was the beginning of this whole idea. And it began in the 1920s with North Dakota being the first bar to integrate and really flowed from there. And so what's being challenged today, really, and you'll hear from the other two speakers, is that principle, and it's reasonable minds can differ. There are constitutional challenges. My view is, and I think the view of many others is, that's been well settled by the U.S. Supreme Court, that it is constitutional to require lawyers to be members of the integrated bar. And then there are regulatory arguments, which we will always have to defend against, and frankly, we need to be challenged, because if we're not handling the enforcement of standards well, then it ought to be taken away from us. But it's the concept of self-regulation. We're the last profession, the only profession in Arizona that continues to be self-regulated, and that's an important concept that also grew out of the whole integrated bar concept, that lawyers are in the best position to establish standards and enforce them. So that's got a little bit of our history and sort of the fundamentals that are being challenged today, certainly in the legislature and elsewhere in the United States. We're not the only state that's facing these challenges, and they happen periodically. And I, for one, think it's a healthy exercise. I think we need to be able to face those challenges, answer those questions, and if we don't answer them to the adequately to the public or to the folks that count on us to do the job, then we deserve to have the model change. But I think we do a pretty good job, and as Jeff said, we're constantly looking to improve what we do. Our discipline system is the envy of the country. It's now a model. Other states come to look at our system, and we send folks out to help other states with their system. Many of our programs have been recognized nationally. We were just recently recognized in the state for our effort to inform the Hispanic community about notarios and the dangers of folks hiring notarios to do what should be legal work. So I think we continue to look for improvement, but I think we meet the original intent of the integrated bar and continue to provide service to the members and the public.
Oh, thank you. From our perspective, I think that there's really only two groups who should be against a mandatory bar association. The first group would be lawyers, and the second group would be not lawyers. To talk about the lawyers part, I will defer.
So my name's Jared Blanchard. I'm an attorney with the Goldwater Institute, and what I'm going to speak about briefly now is the fact that mandatory bars are unconstitutional. Now, the Supreme Court has acknowledged that forcing someone to join a group violates their First Amendment rights. It necessarily does. Freedom of association and freedom of speech can't help but be impinged when you're forced to fund and join a group. Now, the Supreme Court has also found, though, that this violation can be tolerated in certain instances when it's to achieve a compelling state interest. Now, the bar has previously been found, the mandatory bar has been found to be constitutional due to its compelling state interest in improving the practice of law through the regulation of attorneys. There's two cases on point that address. There's Lathrop v. Donahue from the 1960s, and then again Keller v. State Bar of California in 1991. In the Keller case, what was acknowledged is that the bars need to have safeguards in place in order to limit the impingement of members' First Amendment rights only to that narrow, compelling state interest identified in Lathrop, which is improving the practice of law through the regulation of attorneys. Now, the jurisprudence in this compelled association area has been rapidly evolving. It's been changing over the years. You can really see it start to take shape in the 1970s, a case of Bood that allowed public employers or public unions to compel public employees to fund their lobbying activities as it relates to collective bargaining. As a result of that case, there was a case called Hudson that instituted the procedures that were then adopted in Keller for mandatory bars. And those procedures are essentially that members have to be given notice of what a mandatory association is going to be spending its money on, and that money has to be categorized into those expenditures that are related to the compelling state interest and therefore you're required to pay, and those unrelated to that compelling state interest that you don't have to pay. And then members are given the opportunity under that previous case law to opt out of expenditures unrelated, and if they believe that some of the expenditures that they're being compelled to pay should not be compelled, they're given an objection procedure where they can go before an independent decision maker and have their money escrowed in the meantime. Now, more recently, there was a case called Knox v. SEIU that found that the opt-out procedures that have been employed previously are constitutionally dubious. While they overruled a procedure in a very limited context of a after-the-fact assessment that a public sector union made in California, the understanding behind it seems pretty clear, and that's that you shouldn't be shifting the burden of opting out of expenditures that impinge upon your First Amendment rights. You should be affirmatively consenting or opting into those expenditures, because that, unfortunately and unconstitutionally, nudges those being compelled to fund things beyond what they're being forced to fund. Now, the most recent case is Harris v. Quinn, and in that case, the Supreme Court made something extremely clear. There is a test for compelled association, and it has two prongs. First, the compelled association must not compel dues, cannot be able to compel dues for anything that cannot be achieved through the least restrictive means. Okay, and that's my timer. And second, that that it has to have procedures in place in order to collect those funds. Now, regarding the least restrictive means, the bar on its face flunks that test. There's 18 voluntary states that are able to regulate attorneys to achieve the compelling government interests identified in Lathrop without compulsion and without impingement upon First Amendment rights. This has never been put before the Supreme Court in these terms, and since they've found that strict scrutiny is appropriate for mandated associations like this. And so it is our view that the Supreme Court needs to revisit the issue of mandatory bars and find they're unconstitutional based upon the plain fact that least restrictive means are extremely evident based upon the existence of these 18 states that have never forced attorneys to forego their First Amendment rights in order to have safe regulation in those states. And finally, I'd like to close by saying that this reflects the view that Justice Black pointed out in his dissent in Lathrop v. Donahue, and that's that the mere fact that a lawyer has important responsibilities in society does not require or even permit the state to deprive him of those protections of freedom set out in the Bill of Rights.
So those are the reasons why lawyers should be against a mandatory bar. Why should the public be against a mandatory bar? Well, it's for the very reason that John said. Lawyers are a self-regulated industry. Now, that sounds wonderful to us because we are lawyers. But look at it from the public's view, and more importantly, look at it from the larger perspective of something called public choice theory. And I don't know if you may not have heard that term before, but you'll get the general idea, which is that governmental policies, particular economic policies, often don't reflect the interests of the public. Instead, these policies generally reflect the comparative advantage of special interests to organize and exert influence relative to the public. So because lawyers are a self-regulating industry, we have the inside track. We can bend the power of regulation, which is meant only to protect the public good, to protect ourselves from the public, to enrich ourselves at the cost of the public, to protect ourselves from open marketplace competition. And I submit to you that if you look at the Arizona State Bar's history with real estate agents, with lawyers from out of state, with certified document preparers, you will see a long history of lawyers doing what every industry does, which is try to use the regulatory power it has to enrich itself at the cost of the public. Now, just last term at the U.S. Supreme Court, there's a very interesting case called the State Board of Dental Examiners of North Carolina versus the FTC. And what the U.S. Supreme Court said was, of course, regulated industries that regulate themselves are going to do things that hurt the public. And guess what? When they do that, they're subject to antitrust lawsuits. In that case, the FTC brought a lawsuit against the North Carolina Board of Dental Examiners, a board that made up of dentists that regulated dentists and that was elected by dentists. You can imagine what these dentists then did with the powers that they were given. Well, the Arizona State Bar has, at least on its face, a lot of the same structural problems. The State Bar Board of Governors is primarily, in fact, it's dominated by lawyers elected by lawyers. This gives rise to the idea that the elected lawyers have a constituency. Who's the constituency? It's the lawyers who voted the people in and not the public, who could never vote out Board of Governors. Now, I say that, and that's the problem with mandatory bars in general, mandatory bars that require membership, that allow lawyers to control the Board of Governors, and that also have regulatory power. What's interesting in Arizona is that I think our Supreme Court has recognized this problem and has taken steps to combat it. And the ways that they have done that undermine the very purpose of having a mandatory bar. I rather like our disciplinary system. I think that the regulatory function is by far the most important thing that the State Bar does, because that is what protects the public from lawyers. But the regulatory function in Arizona has been largely stripped from the Board of Governors and from the sort of mandatory side of the State Bar. Today in Arizona, regulation is done by professional staff that is quite pointedly by the Arizona Supreme Court not under the control of the Board of Governors. In fact, the Board of Governors has almost no influence over regulations that go forward. It's the Arizona Supreme Court that makes regulations, and it's John and his staff that is in charge with enforcing these things, ethical violations, unlicensed practice, all these sorts of things that are really at the core of what the State Bar does. And so, if for present purposes the State Bar is acting at its core as a regulatory-only function, and in fact not a self-regulated industry, then what is the purpose of forcing mandatory involvement in the State Bar Association? Now, I agree. There has to be someone who regulates, maybe I'll lose my libertarian bona fides for this, but there has to be someone who's regulating the practice of law. That someone can't be lawyers, because we are self-interested, and that's why the public should be greatly concerned about us. So when you put that threat up against what I think is also the threat to the First Amendment, and also the fact that these ideas of professionalism, I don't think professionalism is at issue. I don't think that lawyers in these 18 non-mandatory states are unprofessional. And I don't think that Arizona lawyers were unprofessional before the State Bar was mandatory. So given the threats and given the low benefits, why have a mandatory bar?
Thank you. John, Jeff, any comments, rebuttal? 5 minutes, please.
Yeah. First off, we are different. The Constitution of Arizona says we're different. We're not a bunch of dentists trying to keep other people from whitening teeth. The Arizona State Bar provides not only protection to the public, but doesn't engage in what are considered to be anti-competitive actions, which would fall under the rubric of the North Carolina Dental Program. And to the extent that there is any kind of potentially anti-competitive issue, the court is well aware of it and is either already has or will be taking steps to resolve it. And Paul knows this all too well, because he was a member of that task force that assisted in addressing it. I chaired a task force that also addressed it.
I know everyone isn't going to agree with me on this. I know Jack isn't going to agree on me on this. But I really believe that there are certain services and benefits that our bar provides to our profession and to the public that are akin to roads and police protection. In other words, it is true that you need police protection, and it is true that you may not even use the roads. But as a society and as a profession, there are certain basic benefits that we need to provide, not only protection to the public, but development of lawyers, and safeguard of trust accounts and all those other things. And I don't think that we err too far on the side of overdoing that in what we provide. I think where we err is we don't communicate it very well, and we're getting better at that. That all 5 minutes?
You did very well, thank you. John, you want?
Can I get a minute?
You get
A minute, 30 seconds?
3.
Oh, 3 minutes. So, I got to go back to my bar preparation days and remember the 3 tests, constitutional tests. Remember those? Rational basis, intermediate scrutiny, and strict scrutiny. Strict scrutiny simply has not been applied to bar organizations. Now, certainly the Goldwater Institute would like that to be the test and may successfully get a case before the Supreme Court. But unless until they do, and unless and until the court changes its opinion, that's not the standard. And so the court has said it's constitutional, the integrated bar is constitutional so long as it spends lawyer dues on 2 things, not just the regulation of law, but also on the improvement of the quality of legal services. And that's a pretty broad task, and there are lots of parts of the bar that are engaged in that kind of work. And the second piece with respect to Paul's point about the regulation, and he and I agree on a lot of things with respect to how the work is done. I think it's the oversight of the court that makes us different. The direct oversight and involvement with the court that makes it not completely self-regulated by attorneys. And I think that's part of the reason why the bar is an important, is important to continuing that mission. But it's really the integration of the professional development of lawyers and the discipline that I think benefits the public and the members more so than in a voluntary state. And 30 seconds, it's a little bit nuanced, but the lawyer regulation team that we have at the bar is influenced and directly communicates with the same folks that work on our professional development programs. So if there are problems with trust accounts, then we produce a trust account handbook, and we put that online and we offer it free to our members. If there are problems with lawyers in the practice management area, then we put on programs that lawyers can improve in those areas. Likewise, the lawyers that are involved in the lawyer regulation are involved in those programs and are grounded in their decisions that they make. They are rubbing shoulders with real practicing lawyers every single day. When you separate that entirely from the regulatory process, what you get is an isolated group of folks that really don't have as good a connection to what's really going on the ground. And I think the integration of both of those things really make for an organization that does a better job. Can it be done differently, and is it done differently? Yes, but I happen to think it's done better with this model.
Perfect, thank you. Paul or Jeff?
I would just like to start off by saying that I think the whole discussion begs the question, if you can regulate attorneys without compulsion, without forcing them to surrender any part of their First Amendment rights, why do something different than that? There's 18 states that are able to regulate attorneys without compulsion. I think that Arizona, because of its respect for constitutional rights and free speech, should be among those states. And I also think that Mr. Phelps and the State Bar have done a commendable job of protecting our First Amendment rights from incursion under Keller to a large extent. But I think that there's risks inherent in us having to surrender those First Amendment rights in the first place. And I think this is borne out over the flood of litigation that has taken place since mandatory bars were first found to be constitutional. In fact, I think that my client in North Dakota, Arnie Fleck, provides a great example of this. The North Dakota bar, without providing any of the procedures under Keller, spent $50,000 opposing a family law measure that had nothing to do with the practice of law that he strongly supported, that he spent $1,000 supporting, and that he debated in favor of, only to turn around and find that he also had to fund the opposition. People shouldn't be put in that situation regardless of what their profession is. So because of those inherent risks, I think that we should err on the side of protecting the First Amendment rights of attorneys. And just as an aside, I'm happy to be barred in both Florida and Arizona, and I have to say that Florida is a bunch of dentists. We just got through another round of the Board of Governors keeping the island of protectionism that is Florida and preventing attorneys from out of state from receiving any sort of reciprocity, much to my angry letter writing dismay.
I'd like to take on the idea that the Constitution says that lawyers are different. No, it doesn't. It doesn't say that anywhere in there. It doesn't mention the state bar in the Arizona Constitution. I read it this morning in anticipation of this. It doesn't. I start from the proposition that lawyers are human. The public may disagree with us, but I think we can all agree lawyers are human. And humans are self-interested. Therefore, lawyers are self-interested. And we present all of the same threats to the public that any regulatory capture sort of industry does. We don't like it when mining companies control the regulation of mining. We don't like it when airlines control the regulation of airlines. Why should the public like it when lawyers control the regulation of lawyers? They shouldn't. And lest we think that the Arizona State Bar has not engaged in anti-competitive activities, it has in the past. For those of you who remember Bates v. State Bar of Arizona, we all remember it as a First Amendment case, but it also started life as an antitrust case because there was a bar regulation that prohibited advertising. But there have been other examples, and in fact, the Arizona State Bar's overreach when it came to trying to horn title agents out of preparing fill-in-the-blank documents for property transfers was actually overruled, was blessed by the Arizona Supreme Court and then overruled by the people of Arizona. I believe it's Article 26 of the Arizona Constitution. It was actually implemented to protect real estate agents and title agents from the state bar by protecting their right to work. And it passed when it was put to the public at about a 3 or 4 to 1 clip, which simply shows that as much as people hate real estate agents, they hate lawyers that much more. This is, again, an omnipresent threat. And we can't exempt ourselves from these obvious public choice ideas simply because we trust ourselves. Again, we don't trust any other industry when they put forward these same arguments, and there's no reason for the public to trust us.
Thank you very much. We're going to move to questions now, and before I open it to the floor, I do have something I would like to ask you all to brief us on, and that is for those of us, I suspect many of the people in this room follow this on a daily basis, but for those who may not, can you give us the current status of things? I know there have been some hearings, or if there is there any proposed legislation for the next session already drafted or in the works? And just comment on that if you would. Maybe start with Paul.
Sure. So there's two, I think, what are parallel things going forward at the same time. I'll defer on the task force to John and what the task force was doing, and now what's happening, I think, at the Arizona Supreme Court. On the legislative side, there was an ad hoc study committee put together to talk about the Arizona State Bar. We had a couple of meetings. I was on that task force because of the letter that I wrote, which is I put out there, the reward for work is more work. As of yesterday, the committee voted to approve essentially 4 recommendations. Ones that said the State Bar should be more open in terms of what it's spending lawyers' money on. Which committee? This is the ad hoc study committee on mandatory state bars. I think that's the name of it. In the House.
In the House.
Of the House.
House. So it's a handful of House members and also a handful of public members. All of us were lawyers. Jared and I were both on it. So essentially what it recommended is that the legislation should be drafted, so nothing has been drafted yet, that will encourage the state Supreme Court to adopt certain rules relating to sort of openness of records and things like that. I'm sorry I can't give you the exact details, but there's no draft legislation, and the recommendations that have been put forward are essentially to the legislature should encourage the Arizona Supreme Court to do certain things with regard to the state bar.
John, what?
The task force, sure. So the Supreme Court, Arizona Supreme Court, appointed a task force a year ago last August, and it met for a year. As Paul mentioned, he was a member of the task force. I was not a voting member of the task force, but I was I guess, information provider, a staff attorney to the task force. Anyway, it was composed of 15 folks, a mixture of lawyers, some past presidents of the state bar, and public members, non-lawyers. And it met over the period of a year and looked at primarily two things. The mission of the state bar, it looked at Rule 32 and asked the question, is the mission of the state bar still what Rule 32 says it is, or should it be modified and improved on? And the second component was to look at the structure of the state bar and ask the question, is it structurally sound to do the work that the court directs under Rule 32? And so after a year's worth of considering and analyzing and looking at what other states do and hearing testimony from other folks and studying this matter, the task force issued a report to the Supreme Court this past September. And in it, it recommended a couple of things, and I'll just highlight the three or four top line items and then mention what the bar has done so far about that. It recommended clarifying in Rule 32 that the primary mission of the state bar is to serve and is to protect and serve the public, but also to enhance the development of attorneys, of lawyers, of its members. But it felt that it was not clear in Rule 32 that the primary and core mission of an integrated bar is to serve the public. The second, I think, major recommendation was to change the composition of the state bar and reduce the size of the board. Right now the board is 30 strong, with an additional one member of the Supreme Court who serves as a liaison. So there are 31 folks sitting around the board table once a month. And it recommended reducing that number to between 15 and 18. And it came up with three different variations, and I won't go through those details. But the different variations changed the ratio, and with one recommendation increases the number of public, non-lawyer members on the board and reduces the number of elected attorneys. The other two keep that balance pretty much as it currently is, but simply reduces the overall number. And so I think those are the two biggest issues. It addressed some things like term limits and removal procedures and those kinds of things, some of the mechanical aspects. But I think the mission and the structure, those two recommendations were the biggest. And so right now the court's mulling that over. We think that it may push out some sort of rule petition, probably by one of its staff attorneys. We haven't seen anything on that yet. The board, Jeff Trachtenberg appointed, I should let you talk about this part. You appointed a task force, or working group.
Well, we didn't want to appoint a task force to evaluate the task force, so we appointed a study group to evaluate the task force, and they studied it.
Lawyers.
Yeah, and they studied it and came back with a recommendation about the various aspects of the Supreme Court's task force report. Generally embraced all of it, except for, and this may not come as a shock, they didn't want to reduce the size, and there was some disagreement about. Excuse me, I should add that the study group agreed to reduce the size. I misspoke. The board as a whole decided they didn't want to reduce their numbers in any event. And that has been a controversial thing. And I don't want you to worry about that, because it will take care of itself. And it seems like it's going that way. The one other thing I would add that we are changing, which was something it was near and dear to my heart, because I was very involved in our evaluation of the bar relative to the North Carolina dental case. And so what we have done is we've also further refined the Supreme Court's rules relative to becoming a certified specialist and providing appropriate non-competitive oversight and due process there, which is very, very important and is something that we really learned from North Carolina. But I think the ultimate point is both the court and the bar are listening. We're listening to the Pauls and the Jareds of the world. And we're not listening enough. I understand, but we are listening, and we're trying to make accommodations. And candidly, we're listening to everybody. We're not above changing. We're not above being more transparent. There's a cost benefit to things, obviously, but the long and the short of it is we recognize that we can do things better, and we're going to try.
Thanks. Paul, one quick question for you. The House ad hoc group, did it include members of the State Bar leadership?
It did not.
Okay. But there were lawyers?
Yes.
Okay, very good. All right, questions? Mr. Caston?
Understanding all the points that were made, my question is this. I draw a line in my mind between the disciplinary function that's, I guess, overseen by the Supreme Court, as indicated by Paul. My question for Mr. Felton, the current president, is there anything other than that the State Bar does that it could not do if it were a voluntary bar association?
No, it would be done differently, I think. And so an example is in Colorado, which is the nearest state bar that's has the voluntary model. The ethics hotline, for example. So we have professional staff, 2 full-time ethics counsel that answer the ethics hotline and questions from lawyers that we think is not only a benefit to members, it's one of the most used services, but also benefits the public because it helps lawyers, navigate those issues. In a voluntary bar state, there's not that same level of investment, and so typically the ethics, if they have an ethics hotline, as in Colorado, it's by volunteers, and so there are volunteer lawyers that are a part of a committee, and they volunteer to take the messages and return phone calls when they can get to them. And the difference there is that there's this is the interconnectivity, the integration that I was talking about earlier, where the ethics hotline's informed by what is happening in the regulatory space, and likewise our regulators are being informed. Not specifically, there's a wall there that separates the ethics hotline from lawyer regulation, but they do get information about trends. What kinds of things are lawyers struggling with? What kinds of issues are trending, so that we can put education programs together, and from an enforcement side, also understanding that there are some factors on the ground that our regulators may not appreciate that lawyers are dealing with. So that's one example of where this integration makes it different. But your point is well taken, which is in a voluntary state, do they have sections? Yes. Do they have committees? Do they have magazines? Do they have a directory? Convention, all of those kinds of things. Absolutely, but it's the loss of the integration, I think, that in my view makes it a lesser organization. Jeff, I don't know.
Yeah. The only thing I would add is there wouldn't necessarily be all of these things. I mean, I don't want to focus just on the ethics hotline, but I mean there are other benefits and there are things that would cease to exist, and it's not possible for me to go in chapter and verse, but I mean, just for example, we have a trial college. We have a trial college that we run and sponsor, and it trains lawyers how to actually do a trial. It's a week-long thing, and it is a fantastic program. We have lawyers that come from other states to do it, and it's partially funded by members, but it's partially subsidized by the bar, and so those things may go away. And so my ultimate point is there's nothing that would prevent us from having these things except perhaps economics.
Thank you. Other questions? Yes, sir, Mr. Moody.
example, with respect to the ethics function that the state bar conducts, which I happen to think is very, very valuable. Pat Fallon, who is a former law partner of mine, I think is probably the smartest lawyer at the state bar. He's fantastic. But it seems to me that in working up to this, I've met with several friends and knocked around some of the ideas, some of the things that were concerning lawyers, not necessarily the individual lawyers, but from outward observation. Libertarians on there, and I happen to be a libertarian. I'm both a member of Institute of Justice and contributor to Goldwater Institute. But that doesn't mean I agree with anything. But they spend a lot of time talking about it being a self-regulating, that we've got a self-interest here. Well, the fact of the matter is, the 800-pound gorilla in the room is the Supreme Court of the state of Arizona. And many of the comments that I've heard go to that very issue. And that is the state bar providing an independent function? Because I have had personal experience, for example, when the issue came up as to senior lawyers. A group of senior lawyers, including myself, we, if you will, negotiated with Dan McAuliffe, who was the representative, if you will, of the state bar in the Supreme Court, and we came up with a solution to that. When it got to the Supreme Court said, and they really just tossed out the work product and the petition that the State Bar of Arizona had submitted to the Supreme Court.
You know, Mr.
One of the observations is, what function does the State Bar of Arizona really do when it comes to the end result? Or are you controlled, is the profession really controlled by the Arizona Supreme Court?
Mr. Moody, a couple of things. First off, that brings us back to Mr. Avalar's statement that there nowhere in the Constitution is there a mention of the state bar. That's actually not accurate. The Board of Governors specifically is discussed in our Arizona Constitution several times. But besides that, the fact is the state bar is, if anything, an advisor to the court, and we and a conduit for lawyers like yourself to obtain those kinds of changes. In your case, it didn't work. And by the way, it didn't work the first time. That doesn't mean it won't work the second or third. As somebody who has actually also done that and tried to make some rule changes, some I've been successful with and some I haven't been. Some I've had to try more than once. But the State Bar has been an excellent resource to getting those changes vetted, evaluated, narrowed, and moved along in a way that ultimately, to the ones that were successful, were integral to getting them done. So I recognize that it didn't work out that time, but that doesn't mean it never works. And the fact that Dan McAuliffe worked with you on that is a testament to how involved the bar and committed the bar is to trying to help.
I can tell you with respect to Dan, no good deed ever goes unpunished. If you want to attend, it's better than going to the Phoenix Zoo. If you want to go to a meeting, go to this meeting of these senior lawyers, which occurs once or twice, maybe bi-monthly, at the Arizona Italian Club. It's remarkable. By the way, I want to compliment John, and also Jeff is going to get to go through this experience with respect to the legislative proposal, because I very vividly recall my son happened to be a lawyer lobbyist, so he filled me in on the experience that our delegates from the State Bar of Arizona had. They went out to the committee hearing, and I don't remember if that committee was chaired by Andy Diggs, who was a quote retired lawyer who happened to get the published clearinghouse jackpot. What time did you guys get to testify? What time in the morning was it? 3 o'clock in the morning? I don't remember.
Mr. Moody, we appreciate, we've got a lot of
Yeah.
people who want to ask a question. I appreciate your comments. Yes, ma'am.
Hi, my name is Carol Krug. I'm a lawyer here and in Texas. I was a member of the mandatory Texas bar for 23 years now and going. One of the things that happens in the state where the lawyers don't absolutely hate the state bar is that part of their mission is also to protect their lawyer members. I just got an email here, like in the last day or so, where it was put out there that, oh, good news,
I'm sorry your experience has been that way. I will tell you, we do have that screening function. We absolutely do. And there's no call that is made. Now, that's not true that it was always this way. 4 years ago, it was different. But for the last 4 years, and the email you're referring to is one that I wrote. And you're right. For the last 4 years, you get a call. But I'm sorry if I failed to communicate. It's not everyone gets a call. It is dutifully screened, and many times nothing happens.
Yes, ma'am.
I'm Beth Hall, and I'm here on behalf of the general public, even though I am a lawyer scholar. The state bar is still perceived by the general public as being a state agency. And that's why they get so angry when they call you, because they think you're a state agency, and you're not a state agency. Unfortunately, you're not. Because I thoroughly believe that you should come back into the concept of the state, much like the registrar of contractors. But I do not see that, I mean, you're where you are today because you refuse to give up, under the sunset rules, your books and have them audited. And so if you're not willing to accept the state of Arizona being able to regulate your money to a certain extent and examine it, you're not going to get back where you need to be. You need to be a state agency protecting both the lawyers and the public. And that's not where you are right now.
Thank you.
Could I respond on that?
Sure, briefly.
Yeah, our books are audited every year by a third-party audit, and the financial statements are made open to the public. As a 501c6 nonprofit organization, we file a public Form 990. We put that on our website. And so I think as an organization, as a nonprofit organization, we're pretty transparent. There are other state bars in the country that are part of the state apparatus and are government agencies. So that is a model. It's not the model in Arizona. It's not the model in a majority of the mandatory bar states. But that's certainly, one model that has been adopted.
That was the initial model, and it's the one called by the Constitution, both Arizona territorial and our own Constitution.
This came up during the recent committee hearings of the legislature, and it is one of the peculiar things about the Arizona State Bar. It's neither fish nor fowl, and sometimes both. The State Bar is a private nonprofit organization that exercises regulatory powers. There's not another private nonprofit organization that exercises regulatory powers that I'm aware of anywhere in the state of Arizona. And it's particularly weird because multiple courts, the U.S. Supreme Court, the Arizona Supreme Court, the Arizona Court of Appeals, have all said it's an unconstitutional violation. It's an unconstitutional delegation of government power to give a private organization regulatory powers. You can imagine the reasons why. It's one of the weird things about the Arizona Supreme Court, or about the Arizona State Bar.
Do you know when it became private?
1973, I think, when the Arizona Supreme Court directed that it be.
And for tax purposes.
Yeah, but it's very strange to have a non-governmental agency exercising what is a core governmental power, and I just can't think of any other organization that has that sort of weird structure. Whatever you may think about it, you have to admit that it is odd.
Thank you. Another question?
I didn't get my question
Could we let some other people ask their questions, and then we'll come back to you?
fully answered, just, so you know, so if you can get back to me. then-
Sure, we'll come back to you. Yes, next. Yes, Jack.
I've practiced here for over 50 years, and it has been my observation over those 50 years that there have only been 2 occasions when our disciplinary system has sanctioned large firm lawyers. All of the others have been sole practitioners or small firm lawyers. Is there any explanation for that?
Go ahead, John.
Yeah, I don't have those statistics. I don't know if that's accurate, Jack, that there's only 2 lawyers in 50 years from large firms. Yeah, I don't think that's true. But I will say that this is true of every lawyer regulation system in the country, and that is that for solo and small firm lawyers, there's a higher level of risk. And the reason for that is, in a large firm, they have legal administrators that manage the trust account. They may have a lawyer that's designated as an ethics counsel who will screen ethical issues before lawyers have those. And you know, as a solo practitioner, you've got to do all of those things. And so I think there's, by the nature of the beast, a higher level of risk that lawyers take on. And so with a higher level of risk, there are going to be more violations. The other thing is I think it's somewhere north of 70%. I'd have to go back and check, but I think it's about 70% of the lawyers in Arizona are solo or small firm lawyers. So just the sheer number of lawyers and the vast majority in that category, naturally you're going to see more solo and small firm lawyers. And frankly, that's a big part of the professional development focus that we have at the State Bar, is focused on solo and small firm lawyers. You know, we've increased our practice management portfolio. We've worked hard on CLEs with the solo and small firm section to try to address some of these issues, to try to help lawyers not inadvertently find themselves in trouble with the rules.
I don't think that's overwhelming. I mean, general political and economic observation is that regulations are harder for small groups to deal with than large groups, because large groups can absorb the costs of compliance and all the rest of that stuff. It's the reason, and it's not just in the law field, it's every industry. It's easier to comply. So I'm not overwhelmingly surprised that that's the issue. And my other understanding is that the primary the lawyers who the practice areas that generate the most complaints are the ones that are more consumer driven, criminal defense
and family law,
which tend to be smaller firms and solo practitioners. So that it's not too surprising to me that that's sort of, as a general observation, true.
Thank you. Kyle?
Have there been any studies to determine the cost of the unification?
Not that I'm aware of. I mean, to figure out, you'd have to figure out what the cost of a bar would be otherwise, and it varies state to state to state. And then you'd have to dial in other costs, such as North Carolina, for example. It's North Carolina that doesn't require you to be a member of the state bar, but you have to be a member of a local bar, and the local bars have different costs. And do you dial in the costs of getting CLE, because some local bars provide free CLE to members and others don't, and the state bar does or doesn't? And you know, from my perspective, the costs are.
Let me clarify. Is your question, have we figured out what it would cost the Supreme Court to do what the State Bar is doing now? Is that?
Actually, what Paul addressed.
Okay, I'm sorry.
There are a number of functions that a state bar performs. There is a role of a unified state bar, and if the state bar were to be unified, there would be a cost of unraveling what the state bar does, and B, a cost of administration going forward, both on a voluntary state bar and on the functions that the Supreme Court would have to perform.
Right.
So my question was whether anyone's done a study to see what the cost impact of the unification.
Not that I'm aware. And it's a typical lawyer answer. It's complicated and it depends.
Yeah, and we've looked at the functions, Kyle, of what would transfer over, and a large part of answering that question would be what would transfer over and what would be left, and so.
It would depend on the model.
It would depend on the model, and so a great example is conservatorships. You know, we take custody of all abandoned client files by lawyers that are either disbarred and leave their practice or die without a successor or simply disappear. We have about 4,000 bankers' boxes in a storage facility of these client files that we go through and identify who the clients are, and then we get those files back to the clients. Now, we don't do any referral, so, you know, the client has to go out and find it. They can call the Maricopa County Bar for that, exactly. So, great plug-in, great referral system. But you know, that's something that our bar does, and I think partly because we are an integrated bar, I don't think a voluntary bar would do that. It's pretty costly. It requires a huge, but it's not required. So some state bars, in some models, that's done by assignment, like fee arbitration in our state. So they'll tag a lawyer to do that.
Michael?
Just really quickly, there's also an intermediate solution that Nebraska has recently pioneered due to the commands of their Supreme Court. and that's that the bar remains mandatory. However, you are only compelled to fund the regulatory functions, and then you at another time can fund the voluntary functions and participate in those as a result of funding them. So that's a middle ground approach that one state has taken, and their dues drop from $300 to $98.
On the voluntary side?
On the mandatory side, I believe it stayed around 200 for the mandatory or the voluntary side.
Michael?
Well, since you mentioned the fees, and I know that the panel represented here probably has membership in a number of different state bars, so it's always, as a member of Arizona and California, it's always been somewhat surprising to me how much more expensive the Arizona bar dues are comparatively to the California bar dues. And I don't know, maybe you could tell us about New Mexico and Utah and Florida and whatever other bars.
Florida's very expensive.
Again, to me, that's always represented an example of how maybe our bar is doing too much under its mandatory, obligatory, you have to be a member, that should maybe devolve to the voluntary side of it, or the local bars like the NCBA and so forth. I mean, can
Well, I mean,
can
it's.
each of you address some
Yeah,
Sure.
I mean, I think it's safe to say that Arizona is an expensive bar by comparison. But the difference is in what we do and how we do it is pretty significant.
Right.
I mean, if you want to compare it to California, it's very interesting. The person in the back of the room was concerned about the approach to lawyers, right? California uses some of your bar dues so they can advertise on TV to tell the public to file complaints against you. And so, they'll stand there with a lawmaker, and, Joe Blow lawmaker gets free advertising, gets to stand there and say, have you had a problem with a lawyer? Call the state bar, which is, which would be appalling to lawyers here. So it is different as to their approach as well. So the long and the short of it is, I don't have specifics, but we also have open, and we are not shy about showing where we spend our money. And we just did the budget. We just did the budget this year, and we're very conscientious about cutting stuff.
Yeah.
We don't. The fluff has been cut out in a major way in the last several years.
I think a big part, if I could add to Jeff's comment, a big part of our the cost is in lawyer regulation, and so some folks may look at that and say, we need to cut the number of bar staff, the number of bar counsel, but compare, for instance, Virginia to Arizona. So Virginia, I think the bar dues are $210. Ours are $475. But to resolve a formal complaint in Virginia takes somewhere in the neighborhood, I think it's, last time I looked, and there's an ABA study that captures all these statistics, over 700 days to resolve a formal complaint. In Arizona, it's 111. So, you're paying for a process and a system that disposes of those issues much more quickly, instead of having paralegals or legal secretaries, and we've got terrific paralegals, paraprofessionals working for the bar. We also include lawyers on the front end and screening. So we have a paraprofessional that receives the complaint, goes right to a lawyer, experienced lawyer, who then looks at the case rather than waiting for it to go downstream.
And
So
I'd be
that's a big.
remiss if I didn't
yeah.
say per capita, we actually rank way up there, almost number one in the number of complaints that get filed. So
Wow.
in terms of the activity, it doesn't mean that they turn into complaints. The number of inquiries that are made. So we have a very vocal public.
You need to put more money to the professionals.
We're beginning to run a little low on time, but John, would you like to take another stab at answering the question of my fellow Texas lawyer in the back?
Sure. What
If you could
part
clarify why
didn't
you didn't
Jeff?
answer,
Yeah.
please.
I guess I confused everybody by giving a specific example, but my broad question is, why can't the bar here, let's say you win this fight, make serving the members an equal part of your function with disciplining the lawyers and, whatever else it is you purport to do?
Well, I guess I disagree with your characterization, and the court directs what the bar does, and currently under Rule 32, there is a large responsibility to serve lawyers, and I think that'll continue. I don't think those are mutually exclusive missions. I think by providing opportunities for lawyers to be better lawyers helps to serve and protect the public. So I think I don't agree with your characterization. I think the State Bar of Arizona has a lot of programs and activities to serve our members and to help them stay out of trouble.
But it's not part of your mission statement like it is in this.
Well, again, I disagree with your characterization. If you read our mission statement, it says to serve the public by enhancing the profession of law and articulates specific areas. So I disagree with your characterization.
Yes, ma'am, let's go to your question, please.
Beth Albright, I'm just a member of the public. I'm in the field of psychology, actually. I was looking at your members hate the bar, and I was looking at the statistics, and it says, our survey consultant, Bruce Merrill, a nationally recognized expert, pointed out that given the mandatory nature of the bar, the mandatory nature of membership, the overall number was reasonable. That sentence in itself gives you the dichotomy that the rating might be much, much better if it was not a mandatory bar. Therefore, the attorneys would feel more trustworthy or more trusting of, more represented by, more supported by a non-mandatory bar versus a mandatory nature of membership. You see what I'm saying? You don't see what I'm saying?
Oh, no, I
The fact that he's saying, oh, this is a good statistic, given that it's a mandatory bar.
yeah.
That says it all right there. If it's not a mandatory bar, your statistics might be a lot better.
Well, there's no question that there are the lawyers that don't buy into the idea that the bar has a larger responsibility, not just to lawyers but to the public, would prefer to be in a voluntary bar. And so I think Mr. Merrill's point was voluntary bars are all about lawyers, and really the public is in some cases either an afterthought or secondary, and so that doesn't surprise me at all.
I'd just like to say that that's one of the problems with compelling membership in an association is where the bar may feel it's serving attorneys. I may disagree with that, but I'm still forced to fund it. I can't opt out. I can't leave. For instance, during the last legislative session, I testified before the committee in favor of, I don't recall the House bill number, but it was to unify the bar. And that legislation, of course, was opposed by the bar. And so while at the same time I was working to have that legislation passed, I knew that I was compelled to fund the opposition. That's not really a position anybody should be placed in under the Constitution.
Yeah, but this is, the last couple of questions I think have gotten to the inherent tension within a mandatory bar. The members think that a bar is to serve member interests, and the public thinks that the bar is meant to serve public interests. And sometimes those two interests get crossways. And what happens, what does a bar do, what does a mandatory bar do when those interests get crossways? That's a lot of the reason why a non-mandatory bar with a regulatory agency only is a purer system. There may be, we may lose some things that the mandatory bar provides. But what it does is it breaks that tension. So now lawyers can have their own interest group and be full-fledged in favor of lawyers, and the regulatory agency looks out for the public, and I think that's the better way to go. But that's the inherent tension.
I'm sorry, let's go to the gentleman next to you, and then if we have time, we'll come back to you, your question.
I'm a member of a citizens group called Citizens for Clean Courts. We're the ones who sponsored that particular legislation that you were fighting for and came for those fighting against. The question I have is we have, I think, 23, I'm got my glasses on, 23 disbarments on this sheet of the history. I hearken back to the military and the Judge Advocate General's office, and when anybody in that arena is charged with anything, the association defends it or her. well as prosecute. What I see in the State Bar and the discussions I've had with other members of this group that happen to be disbarred lawyers, that were disbarred and tried, prosecuted by this very board, they didn't have any defense paid for by the organization that they contributed money to throughout their career. There's something wrong with that. And then I get back to NCBA. What is the difference between the Maricopa County Bar Association and the State Bar Association? Is there a redundancy here? This is a voluntary, as I understand.
Yes, sir, you're correct.
And what is it that you do that they don't do, and what is it that they do that you don't do?
No, we're actually older. We were founded in 1914, so we're actually 20 years older than the State Bar. I should let one of the panelists answer, but the short answer to your question is that we do most of the things. We do continuing legal education, which is a big thing that the State Bar does. We have, of course, have no role in regulation whatsoever, except when the people call us and are confused about who they should be calling, and we send them to the State Bar's discipline department or Bar Counsel's office.
Why don't you have a role in regulation or enforcing the ethical nature?
Because we have a unified State Bar, and we have no desire really to do that. I hope you don't mind me saying this, but we are focused on lawyers and making lawyers better lawyers through education, through publications, through things like that. So,
Do you defend them? Do you defend your members against that group?
no, we don't have the resources to do that. Would that I've never even thought about such a thing, but.
Although we may do the lawyer referral service.
Yes, we will help you find a lawyer. We can do that. We can do that. Anything? Yes, sir.
I'm sorry, I didn't get my question.
Oh, I'm so sorry. Go ahead.
Well, I'm asking, why is it that this particular State Bar will prosecute the
Oh,
members that
go ahead.
they-
I'm sorry. This is a former member of the Judge Advocate General School.
Yeah, so you're right about the military, but with respect to the military justice system, which is the criminal cases. So these cases with respect to the disbarment or suspension or other penalties are administrative, not criminal. And so criminal cases are much like in the civilian world. If you're indigent and incapable of providing for a defense, that will be provided for you in a criminal case. And so that's also the case in the military. It is also the case in the military if you're talking about defending your license. For instance, when I was an active duty JAG, I was a member of the Arizona Bar. If and when there was a complaint against me, I had to defend that myself. That was not provided for by the military. So a civil or administrative hearing with respect to licensure is not defended. The organization doesn't provide it. Now, as a policy matter, could the board or the court decide to provide that? It could. There'd be a cost associated with that, but that's not the general practice anywhere else in the country, and certainly not with respect to other licensing agencies.
Well, with JAG, of course, as a member of the military, I didn't have to pay for your services. That was there. In this case, as a lawyer, I have to pay you to be a member. I'm compelled to pay you to be a member. But then if I overstep my bounds, or somebody perceives I overstep my bounds, then I am now paying for my own prosecution.
Well, I mean, that's the way that regulatory bodies work. Let's take something like doctors and the Arizona Medical Board, which is not the Arizona Medical Association. It's different. The Arizona Medical Board, you have to pay to maintain a license. And the cost of the license is essentially, especially for them, it's meant to offset all the costs of the regulation. The idea is it's the industry that's being regulated will pay for the costs of the regulation. Don't know how it works out in practice, but that's the theory. If a doctor's license is being threatened by the Arizona Board of Medical Examiners, Arizona Board of Medical Examiners is represented by the Attorney General's office, but the individual doctor is responsible for his or her own defense to that action. That's, in that sense, the Arizona Bar Associations, again, their regulatory functions, their disciplinary functions, looks very much like a standard, regulatory-only body, and that sort of model is true for doctors and dentists and cosmetologists and barbers and lots of other sorts of professions.
Do we have anyone who
Lawyers and
hasn't asked a
voluntary
question?
states.
Because we need to wrap up really quickly. I'm sorry. Go ahead, sir.
I have no real beef with the state bar. Christmas, I'm actually from New York, so I'm one of those 18 guys. And I just want to point out there are some benefits to having a capitalistic system as opposed to the mandatory system that you currently have. And that is that you compete for people to be a member. In other words, I don't want to be a member of your group because you're not doing what I want you to do. But as I say, I have no beef with the current system, but I will point out that in New York, there was a distinct benefit to the New York State Bar being independent from the state system of Office of Court Administration. The State Office of Court Administration does the disciplinary proceedings against lawyers. They do it through their various appellate divisions. And thank God I've never been a participant, but they're in, and there are lawyer complaints handled through the local bar associations initially. And if they work their way up, well, that's fine. But all the locals and the state bar are all voluntary. And we have plenty of complaints that are handled, and they're all handled very assiduously because nobody wants to let things fall through the cracks, and it's work. So as far as the complaint aspect, as far as complaints being handled, I think that either way is probably fine, but it's also going to work equally fine under the capitalistic system. The capitalistic system in New York State, which I actually fled from for other reasons, it's more or less a socialist state in so many ways. But that system recently, there was a proposal by Chief Justice Judith Kaye from above. We will mandate. Everybody loves the word mandate. It's when it applies to them. You mandate somebody else to go do something. Yeah, he's mandated. All right, I'm feeling good. But when they mandate you, it's generally because you don't want to do it. So, and we all figured out how we got here in this country and how we did so well. I'm wondering why we have to have so many mandates, particularly at the federal level. But Judge Judith Kaye wanted to mandate that there will be mandatory pro bono legal services, period. And you're going to do it, or you're not going to be a lawyer. Well, there was nobody to oppose her except for the voluntary State Bar Association, who did oppose her. And you're probably familiar with what happened. There was a compromise reached on that. And it would not have been compromised but through the good old advocacy system. Where do we have advocacy? Oh, I'm sorry, courts, that's right. We don't have this French magistrate system. We don't have the House of Lords. We don't wear wigs. We got advocates. We got capitalism. And I tend to believe there are probably certain benefits to introducing that into the State Bar of Arizona without sacrificing many fine services that your organization already has.
Well, on that note, I think we will wrap things up unless you just have to respond.
I was just going to say, with respect to the New York, you may, and I'll send you the report. The New York State just completed a year-long commission on the disciplinary system in New York, and found it wanting in many, many areas. And the commission produced a series of recommendations, many of which mirror what we've adopted here in Arizona. So I commend that report to you. You're right. In some districts, discipline is handled very well. In some of the other ones, pretty poor statistics in terms of how long it took to resolve cases and the processing of cases. And so that was local and regional. But I commend that report to you because it's I think that would update folks on the difference.
I'd just like to quickly point out that our regulatory functions of our bar are modeled on the voluntary bar state of Colorado. That's where we got ours.
Which are cheaper. We do it cheaper and we do it faster.
There you go. All right, on that note, we are adjourned. Thank you so much. Look for our next forum in 2016.